Good morning. My name is Tamika McDonald, and today I will be talking about the contract process and contract breach. Thank you for joining me. Let's start with contract breach. WEC's definition team says a contract breach is when one party of the contract does not do what it is supposed to do for the other party. For example, a moving company who does not deliver your items by the specified and agreed upon date of delivery can be considered as in breach of contract. There must be an agreement for the delivery of goods or services that has been accepted by both parties. It can be either verbal or written. To commit a breach, the agreement must be broken by either party. There are various types of breach. Anticipatory breach, which means that one party states that they cannot deliver or will not deliver the specified or agreed upon goods and services prior to the work ever starting. Actual breach is when a party refuses to fulfill the terms of the contract. Material breach is when the failure is so great that it renders the agreement irreparable. And thank you so much for that information, RSTEM. Now, let's move on to damages that can occur when a breach has been ensued. When a breach of contract happens, the hurt party can receive damages or sue for damages. Compensatory damages are, or according to YouTube, the compensatory damages, this remedy allows for the damaged party to be compensated at the amount that returns them to the state they were prior to the breach. And thank you so much for that. Breach, damages, and remedies in contract. Found that on YouTube. Liquidated damages. These are the damages that are specified or that are listed in the contract that will occur if a breach occurs. So for example, if you are running a customer service center and you hire a contractor and they are to answer X amount of calls within an hour, if they do not answer X amount of calls, then there is a liquidated damage that is normally created by a formula that shows exactly how the company will suffer should this particular item not be reached. So should the phone calls not be answered within that hour, then the company itself will hurt some kind of way. So the liquidated damages that are listed in the contract is what will be paid out for this particular breach. Nominal damages is really a small amount or a small fee of damages that's used to signify wrongdoing and often supports what the damage is. So it just shows it's a fee or an amount that's paid that says, hey, yes, this wrong happened. Some damages are paid out of court, and then sometimes it happens where someone else has to get involved for the damages to be decided upon. And when that happens, these are the remedies to satisfy a breach of contract. They include negotiating and a settlement. So you can negotiate with each party can negotiate and come to an agreement on a settlement amount or how it will be settled. Mediation or arbitration, this usually involves someone from the outside to come in and be part of this conversation. And litigation. Let's move on to the steps of preparing a contract. So the very first step is to prepare the contract. This is when the organization or the two entities are required to make sure that the information is in the contract. Negotiate and collaborate. You're going to work back and forth with both teams or both entities to ensure that both parties are reviewing and collaborating and talking about any requested changes. For example, requested changes or exceptions taken to the terms and conditions. This step often can involve legal. Review and approve. You want to make sure that all of the changes have been reviewed and are accepted and have been approved. And this could include managers, officers, or stakeholders. Administration and execution. This is the part where the contract is signed. Now that you have negotiated, you come to an agreement, now the contract is signed. And management and renewal. So the management piece is just making sure that all of the deliverables and everything, that the contract is going smoothly, and that any modifications that may happen to the contract, changes in scope, are being amended within the contract, and those amendments are being released and signed. Also, you want to make sure that any renewal notices, which means extending the contract beyond its natural term or its base term, are being executed. Contracts can be complex. The process can be complex. And the reason for this is because it just takes time. It takes time to pull it together. You want to make sure that all of the items are in there and that the contract is effective. You also want to make sure that it clearly identifies the expectations, and organizations utilize contracts because it helps their bottom line. It helps to protect their revenue and profitability. Thank you so much for joining me.